The gentleman from South Carolina.
Thank you, Mr. Chairman. I'm a lot more interested in having a balanced investigation than I am a balanced hearing. And in that light, Ms. Eckelbrett, did you hear the President say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the President say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the President says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the President say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the President how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course, and you and I both respect that, because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement and a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow,
yes,
I want to say this. I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No, I agree with you 100%. And I also would point to the email of June 14, 2012, which was just released, because this shows the need for a special prosecutor at this point on the criminal aspect of this. And again, Mr. Cartwright, when you asked about the no evidence of politics, let me quote from the email. Don't know who in your organization is keeping tabs on C4s, but since we mentioned potentially addressing them off-plan in 2013, I've got my radar up, and this seemed interesting. These are coming from the most senior people within the Chief Counsel's Office of the IRS, which is a presidential appointee. Again, it's an office I came out of, so I have due respect for the office. But at this point, a special prosecutor to evaluate the criminal sanctions or criminal laws applicable would probably be the best, I believe would be the best way to go, because I don't think the Justice Department right now, again, with due respect to the Justice Department, is institutionally capable of doing this. And I need to say this also, because I thought that the question, Mr. Cartwright, on Ms. Mitchell's legal representation. She has an exceptionally excellent reputation in this town as a lawyer. And her clients tend to be conservative because that's who her clients tend to be. But, you know, I'm a conservative also, but like I said, I've represented the American Civil Liberties Union in cases at the Supreme Court of the United States. I've represented the National Democratic Policy Committee as well. So I don't think it's fair to go after the lawyers in a situation where it is the IRS that is trying to use their procedures to justify their illegal conduct. Remember the apology? They offered the apology. You know what? The apology is not accepted.
Mr. Chairman, in conclusion, I believe the ranking subcommittee member said that there are 13 people assigned to this investigation, if I heard correctly. 13 people in 6 months have not had time to interview a single solitary one of Mr. Sokolow's clients. 13 people in 6 months have not had time to interview either of these two witnesses, and yet the chief executive, the President of the United States, has already prejudged the outcome of this investigation. So either it's ongoing or it's not. Either he's wrong or Eric Holder is wrong. In either case, it is time for special counsel.
And Feinstein is flipping sides. We'll show the video of what she just leaked about Loretta Lynch. Joshua Kaplan at the Gateway Pundit gives us the background. He's reporting that the former Attorney General Loretta Lynch was exposed by James Comey during his Senate testimony when he revealed that the former Attorney General directed him to call the FBI's investigation into Hillary Clinton's email server a matter. Well, it looks like the admission set off alarm bells within the Democrat Party. A high-ranking senator, as we just stated, Dianne Feinstein, calling for an investigation into whether or not Lynch tried to help Hillary Clinton during the 2016 election. Take a look.
That was, of course, the focus of this hearing, but there was something else we learned separately from Jim Comey, and that was some tough words that he had for the former Attorney General Loretta Lynch under President Obama. Comey thinks that Lynch improperly injected politics into that investigation of Hillary Clinton's emails. Here's what he said about that.
The Attorney General had directed me not to call it an investigation, but instead to call it a matter, which confused me and concerned me. But that was one of the bricks in the load that led me to conclude I have to step away from the department if we're to close this case credibly.
Comey said that Lynch, the request gave him a queasy feeling. He felt clearly that Loretta Lynch was giving cover to the Clinton campaign. Was she?
I can't answer that. I would have a queasy feeling too, though, to be candid with you. I think we need to know more about that. And there's only one way to know about it, and that's to have the Judiciary Committee take a look at that.
In other words, an investigation into Obama's Attorney General Loretta Lynch. Now, according to The Hill, they are reporting that Senator Dianne Feinstein said on Sunday that Congress should investigate whether the former Attorney General Loretta Lynch pressured the former FBI Director James Comey to cover for Hillary Clinton's presidential campaign. Quote, I think we need to know more about that, she told the host Brianna Keilar on CNN's State of the Union. Quote, and there's only a way to know about it, and that's to have the Judiciary Committee take a look at that. You heard her say it. She is the top Democrat in the Senate Judiciary Committee. And as you know, Comey testified last Thursday that he felt queasy after Lynch asked him to characterize his probe into Clinton's emails or investigation into Clinton's emails as a matter rather than what it really was, an investigation. He told the Senate Intelligence Committee that such a request would match the wording of Clinton's campaign. So looks like we may see another investigation yet on the horizon, this time taking a look at Loretta Lynch and Comey, their relationship to the Clinton campaign, and of course adopting campaign language so that Hillary Clinton would not lose points in the public eye by simply calling it a matter, right? Wow, this is huge. So get this out there on social media. You're not going to see this anywhere, but we will present you the facts as we see them and call it like we see it. Comment below. See you at the next report.